This recording considers the private international law rules of the European Union, particularly the Brussels 1A regulation and the Rome 2 regulation. Now, private international law has a particular importance in the context of SLAPPs because of the opportunities provided for forum shopping, and also simply as a consequence of the fact that international litigation can constitute a chilling effect on public participation because the lack of familiarity with judicial procedures and indeed the substantive law of other states can pose a significant burden, both financially insofar as discovering how the foreign system works, but also psychologically insofar as a lack of familiarity with a foreign law and a foreign judicial system can be essentially quite scary, quite troubling to a respondent who does not know what to expect. Now, the Anti-SLAPP directive has only very limited provisions which explicitly address private international law, and what it deals with is the treatment of litigation and judgments of third countries. It does not deal with conflicts in an intra-EU sense. What follows then is a slightly dispiriting discussion focusing on the problems in the current EU rules on jurisdiction, which is to say which courts can hear a case, choice of law, which is to say which substantive law a national court will apply, and the recognition and enforcement of judgments. I do highlight some potential routes to defend against SLAPPs in this context. And it's also worth bearing in mind that European Union institutions are considering the problem of the Brussels 1A regulation and the problem of the Rome 2 regulation separately to the discussion on the Anti-SLAPP directive itself. So there is some room for hope that the legislation will be improved. However, at this stage, we obviously need to consider the legislation as it is. There are no firm proposals on how to reform the law in the short term. So the agenda for this discussion is to begin first of all by addressing the gaps in the Rome 2 regulation on choice of law in respect of non-contractual obligations, and then we'll consider in more depth the Brussels 1A regulation and consider potential defences both to the exercise of jurisdiction by a court and potential defences to recognition and enforcement of judgments. So to begin with, the discussion about jurisdictional rules has important implications for choice of law. The reason for this is that while the exercise of jurisdiction, so which court can hear a claim, and the decision as to the applicable law, which is to say which law the national court will apply, while those are separate questions, because there is no rule in the Rome 2 regulation concerning which national law will be applied, which substantive law will be applied in respect of defamation and privacy claims, that means that each national court will apply its own procedural rules to determine which substantive law it will apply. So there is no predictable system, there is no uniform system for national courts' decisions on which substantive law they apply to a dispute. What that means in practice then is that given that whichever national court is seized of a claim, whichever national court hears a claim will apply its own rules as to the substantive law which applies, then the rules on jurisdiction, the rules on which court can actually hear a claim, are crucial not only in terms of where a claim will be heard, but also in terms of which substantive national laws apply to a case. Now, in practice, what that means is that because you cannot predict which national law will apply to a defamation claim with absolute certainty because of the exposure to so many different courts and therefore the exposure to so many different legal systems, this means that respondents or potential respondents need to be very careful to consider what is the common standard of freedom of expression which they must uphold. And of course, that means, in a sense, that we must look to the lowest common standard of freedom of expression to ensure that clients do not fall foul of any national laws which might be relevant, because any of those national laws might come into play because of the absence of a predictable rule which will be applied in the same way by all courts of the member states. So our discussion of the Rome II regulation really is limited to the absence of a rule. Basically, there is no harmonized rule on defamation claims, on which law will be applied to a defamation claim, and accordingly the question of jurisdiction then opens up the possibility of different national laws applying to the claim. So there's a significant incentive for forum shopping by SLAPP claimants. We then need to look at which courts can actually hear a claim under the Brussels 1A regulation concerning jurisdiction and recognition and enforcement of judgments. Now, the regulation begins with a basic rule which recognizes that people should be sued generally where they live. So under Article 4.1, the basic rule provided in the regulation is that a person may be sued in the member state in which they are domiciled. Now, for a natural person, that means the place of their residence, the place where they live. For a legal person, of course, a legal person doesn't live in a particular place in the same way as a natural person, and there is a bespoke rule which says that the domicile of a legal person is either their statutory seat, their central administration, or their principal place of business. In any event, either a natural person or a legal person may be sued in the place of their domicile. That's the general rule. However, the regulation also includes exceptions to that rule. And crucially for our purposes, one of those exceptions refers to tort delict or quasi-delict. And of course that includes most of the heads of jurisdiction on which a SLAPP could be based. Now, in matters relating to tort delict or quasi-delict, the courts of the place in which the harmful event occurred or may occur may also be seized of a claim. And crucially, it is for the claimant then to choose whether to sue in the place of the defendant's domicile or in the place where the harmful event occurred or may occur. Now, that may occur is crucial as well in our context, because you don't necessarily, in order to seize a court of a claim, you don't actually need to prove that actual harm has occurred, but you need to prove that actual harm could occur. And of course that's crucial in the context of SLAPPs, because it means that the claimant doesn't actually need to show that they've suffered actual damage yet in order for a court to be seized of a claim. So the basic structure then is a claimant may choose entirely at their own discretion whether to sue a defendant in the place of the defendant's domicile or the place in which the harmful event occurred or may occur. Now that presents further important definitional questions. We need to understand what is meant by the place where the harmful event occurred or may occur. And that is more complex than it may appear, because of course you can imagine a situation where the act which caused harm took place in one member state, while the result of that act was felt in another member state. And the perfect example is actually the leading case on this question, which is the Bier judgment, in which pollutants were disposed of in the Rhine in France, in the River Rhine in France. So they're disposed of in a river which flows downstream into another member state, in this particular case into the Netherlands. the pollution in the Netherlands causes damage in the sense that that a nursery needs to, a flower nursery needs to expend further funds in order to clean the water to use for irrigation. And the question then is whether in that situation the French courts are the courts of the place in which the harmful event occurred, or whether the Dutch courts, the courts of the Netherlands, are the courts of the place in which the harmful event occurred. Well, the Court of Justice in Beer established a principle that the place in which the harmful event occurred could refer to either of those places. So the claimant then can choose, in addition to being able to choose to sue in the place of the defendant's domicile, they can choose also to sue in the place in which the harmful act was committed, or rather the alleged harmful act was committed, or the place in which the alleged effects of the alleged harmful act were manifested or could be manifested. So there are three choices presented to the claimant on the basis of the basic structure of this rule. And in Sheville, the court found that the principle also applies in respect of defamation claims. So in respect of a defamation claim, you can sue somebody either where they live, where they are domiciled, or in the place where the relevant material was published in the first instance, or indeed in the place in which that material was read, and therefore where the reputational harm may have been felt. Now that presents, of course, a further problem, because the place in which a publication is read could, of course, be several places. Publications can be available in multiple jurisdictions, and indeed that's especially the case in the context of online publication. So if something is published online, in principle it can be read anywhere, and therefore reputational harm can result anywhere. It follows then, because this rule continues to be applied also in respect of online publications, that a claimant may sue in the place of the defendant's domicile, in the place in which the material was published, from which the material was published, and in every place in which the material was available, and therefore in which the material could have caused harm to the claimant. That means then that a publisher is open to litigation in pretty much every member state, or at least the argument can be made that they are open to litigation in every member state. Now, the Court of Justice qualified the way in which this works. They qualified the way in which this works by establishing a rule that you can only sue for the global amount of damages in either the place of the defendant's domicile or in the place of the claimant's centre of interest. What that means then is that the claimant then has a further choice to make, and again, this is the claimant's choice. They can sue for everything in one of two places, the defendant's domicile or their own centre of interest. They can sue for the removal of material also only in those places. But they could also choose instead to sue for damages in every member state in which damages have arisen or may arise. And this is called the mosaic approach. So rather than going for the full picture in one place, you can sue for damages, for the portion of damages arising in a particular state in that state, and then you sue for the other portion of damages in the member state in which that other portion of damages arose. And then the mosaic metaphor, by suing in all of those places, the different parts put together the global claim for damages. In terms of the damages awarded, in principle, although not necessarily in practice, this should have no effect. If somebody loses all of the relevant claims, the global damages award should not change as a consequence of suing in multiple states. Although, of course, in the absence of choice of law rules, as mentioned earlier, that could be the case. You could have a different global award of damages because different laws might be applied. So the mosaic approach also presents some opportunities in respect of the global amount of damages. But crucially, what it does is it exposes the respondent to litigation in multiple states. It exposes the respondent to the cost, and by cost, I don't only mean the procedural cost and the cost of lawyers, but also the time spent and the investment and the psychological burden of exposure to multiple legal systems and multiple proceedings at the same time. And recall that all of this is determined at the claimant's discretion. The claimant can choose where to sue, which is to say they can choose between the place of the defendant's domicile, the place where the damage occurred, and that means both meanings of the place where the damage occurred, and they can also choose whether to adopt the mosaic approach or to go for the global claim for damages in a single state. All choices which legitimately, according to the law at least, the claimant can exercise. And of course what that means in the ordinary course of things is that the claimant can, who has suffered damages, can choose an appropriate litigation technique, possibly with reference to the situation of evidence and so on and so forth. But in the hands of a SLAPP claimant, in the hands of somebody who wishes to vex the respondent, who wishes to use litigation to harm the respondent rather than to enforce a claim, the jurisdictional rules provide ample opportunity to cause that harm. So this is a significant problem, and indeed it is a significant problem which we know about because of some exposure of the deletion of material online when these claims have been made, such as in the Pilatus Bank case in Malta. But of course there's little litigation about the SLAPP relevance of these rules, because very often these claims simply don't go to court. It's simply as a function of the huge burden, the huge cost imposed on claimants who often simply cannot afford to take this further. That said, there are some potential defences to the exercise of jurisdiction. First of all, if a court is to be seized of a claim, it must be shown in accordance with national law that the claim meets the threshold of harm which is required by national law. So in each of your own legal systems there will be rules which a court must consider as to whether it should assume jurisdiction, and if the threshold of harm is not met, then the court will not assume jurisdiction, and therefore there are routes to have claims dismissed at the jurisdictional stage in the national laws of each member state. That said, it's worth bearing in mind that the national courts must consider whether the claim is sound. They can't simply dismiss it offhand. So they need to, under current rules, they need to look into the claim as to the exercise of jurisdiction carefully. They are required to assume jurisdiction unless it can be shown that the threshold of harm is not met. And indeed, in some member states, they simply will assume jurisdiction if a claim is lodged, so there's very limited grounds to contest the exercise of jurisdiction in national law. Also problematically, simply contesting jurisdiction alone can be very expensive. In some member states, the costs could mount to such an extent that a defendant from a legal system in which there are significant cost of living differences, for example, might simply find it prohibitive to defend themselves in the state in which jurisdiction is asserted by the claimant. So there are several opportunities here to assert jurisdiction and to take advantage of the disparities between income in different member states and therefore between expenses in different member states. There are some routes to defences in the regulation, but they are somewhat limited. There could, however, be some more creative routes to contesting jurisdiction. Again, bearing in mind, of course, a key question, which is, well, can your client actually take this to court? So the arguments can be made. The arguments can certainly be made in the pre-litigious phase, but obviously this is, in the current state of the law, this is contingent on the actual dynamics of the case in hand and the extent to which a claimant is willing to take the case forward. But obviously, at the pre-litigious phase, arguments can be made, and whether matters go to litigation is a decision to be made in individual cases. And one route to contest use of the mosaic approach in particular presents itself in the Ali Gurbush case, Ali Gurbush versus Turkey, which is actually a criminal law case, but might be of some use in the context of civil defamation proceedings as well. So in this case, what was happening was there were multiple criminal defamation proceedings brought against Mr. Gurbush in Turkey, and the claims were essentially usually vexatious. There was no real ground for the claim to proceed, to really go anywhere and lead to a criminal conviction. But ultimately, there was a constant threat of criminal conviction and a constant burden of litigation, both economic and psychological. Now, the psychological threat in this case is, of course, different from a civil claim because it includes the threat of the deprivation of liberty, and that does not present itself in a civil defamation claim. But the overarching argument concerning multiple proceedings and the danger which multiple proceedings present to freedom of expression, the chilling effect which multiple proceedings have on freedom of expression, particularly in the context of the mosaic approach to jurisdiction, could be raised in a civil claim as well. So there could be a line of argument developed on the basis of the reasoning of the European Court of Human Rights in the Ali Gurbush versus Turkey case. That said, of course, in order to challenge the operation or the interpretation of the Brussels 1A regulation, you'll obviously be aware that it is only for the Court of Justice of the European Union to make that determination. National courts cannot make that determination themselves concerning interpretation of the regulation. So this would require a reference to the Court of Justice of the European Union. And again, this presents a couple of problems. And those problems, first of all, include the additional expense of proceedings before the Court of Justice. And secondly, there is another problem, which is even if you do get to the Court of Justice, you might find that the Court of Justice displays a degree of reticence when it comes to arguments about changing its previous interpretation of the law. The Court of Justice does not tend to revise its previous decisions. It might refine them. It might provide some cushioning of the previous principle, but it would be unlikely for the Court of Justice, solely on the basis of the existing legislation, to find that the mosaic approach actually did breach fundamental rights protections. Of course, there still would then be a route to the European Court of Human Rights if all domestic remedies had been exhausted. The relationship between the European Court of Human Rights and the Court of Justice of the European Union is, of course, a separate subject of discussion, but it's worth noting that European Union decisions are subject to review insofar as member states of the European Union are party to the European Convention on Human Rights, and there then could be a potential route to challenge the deployment of the mosaic approach, or at least extreme deployment of the mosaic approach in the European Court of Human Rights. But again, of course, this is all subject to a case presenting itself where a client is able to take the case to its full logical conclusion, and that, of course, requires resources which might not always be available. So that's the existing law. Now, does the Anti-SLAPP directive present any opportunities to contesting jurisdiction? Well, it actually could present some opportunities, both in respect of the exercise of jurisdiction generally, and also in respect of the Mosaic approach in particular. First of all, if a claim is disproportionate, excessive, or unreasonable, it needs to be dismissed as a SLAPP, or at least, if it is not manifestly unfounded, anti-SLAPP remedies need to be provided, including the pendente lite, the pendente lite remedies of security for costs, and ultimately the payment of costs if the claim does prove to be a SLAPP once the full case has been considered. So there is, because the directive, the proposed directive, defines abusive purposes as including disproportionate, excessive, or unreasonable claims, there is an argument that the exercise of jurisdiction by a particular court could be excessive or unreasonable, because of course the claimant might try to persuade the court that it should exercise jurisdiction, even though there's very little actual potential for harm to have arisen in a particular state. So there is that potential route. And in addition, of course, the existence of multiple proceedings in relation to the Mosaic approach could itself be considered to be an element of abuse if, of course, there is an excessive use of the Mosaic approach. So there are a few opportunities. The Anti-SLAPP directive does provide some opportunities, but of course it must operate in the context of the Brussels 1A regulation. It does not overturn the Brussels 1A regulation. It perhaps serves to provide as an interpretative tool to the manner in which the Brussels 1A regulation will operate in practice, and therefore it could blunt the sharper edges of the Brussels 1A regulation in practice. And of course, bear in mind that ultimately every state which applies the Brussels 1A regulation would in principle also be subject to the Anti-SLAPP directive, and therefore the rules on the exercise of jurisdiction will be considered in the context also of the rules on anti-SLAPP protection. So the directive doesn't solve the problem, but it adds a potential layer of protection, a potential route to limit the exercise of jurisdiction, and at least a degree of security, even if jurisdiction is exercised unreasonably in the courts of multiple member states. So the opportunities for forum shopping essentially become less accentuated, because all of the member states apply the anti-SLAPP directive, and all of the member states therefore must consider whether a claim is abusive with reference to the definitions of abusive purposes as established in the directive. So there is some room for the use of the directive to limit the more detrimental effects of the Brussels 1A regulation. Now, we've addressed so far the problem of the exercise of jurisdiction by a national court. That said, of course, a national court, if it does exercise jurisdiction, may deliver a judgment, and that judgment in the current state of the law may be the product of a SLAPP, and every judgment given in a civil or commercial matter by the courts of a member state must be recognised and enforced in other member states. So the question then is whether, if a judgment given in state A is delivered against a client, could you argue in state B that the judgment should not be enforced there? So, for example, if your client's assets are situated in France, can you argue in France that a judgment given by an Italian court should not be enforced in France against your client's property? Well, ultimately, because the Brussels 1A regulation is intended to enhance the free movement of judgments, regrettably there are limited grounds to contest the recognition and enforcement of judgments. So the assumption is that a judgment is automatically recognised and enforced in another member state without the need for any special procedure. And importantly, at the recognition and enforcement phase, the court in which recognition is sought cannot reopen the question of whether the court of origin appropriately exercised its jurisdiction. So you can't address the jurisdictional question at this stage. You can only rely on defences to recognition and enforcement. And those defences are then enumerated in the Brussels 1A regulation as well. They're limited. They essentially refer to public policy. They refer to judgments in the absence of appearance by the defendant, and they refer to judgments which are irreconcilable with earlier judgments. Now, importantly, in this context, there is that public policy defence. And of course, if a judgment of a court in Member State A is considered to be excessive in the quantum of damages, for example, for the purposes of State B, that could constitute a breach of public policy. But of course, the argument would need to be made in the national court, and there is a significant question about the extent to which, in those circumstances, clients would usually be sufficiently resourced to contest the recognition and enforcement of a judgment and reopen proceedings on the basis of a public policy defence. So ultimately what we've seen in the context of EU private international law is a landscape in which there are significant problems because of the rigidity of the interpretation of the Court of Justice and the ample opportunities given to claimants to seize the jurisdiction of multiple courts, and also, in the absence of harmonisation of choice of law, to rely on multiple national laws or the threat of the application of multiple national laws. As we've seen, there are some routes in the Brussels 1A regulation and in national law to contest the misuse of jurisdictional rules. There are some rules also in the Brussels 1A regulation to contest the recognition and enforcement of judgments, but those routes are limited at this stage. Once the Anti-SLAPP directive is adopted, there will be further potential routes to limit the sharper edges, as we've said, to blunt the sharper edges of the Brussels 1A regulation. However, ultimately, until the jurisdictional rules and the choice of law rules themselves are considered, there remain a number of difficulties, and this is of course an area which lawyers will need to keep a close eye on to consider whether EU law is evolving in a direction which provides a better situation for people who are exposed to SLAPPs within the European Union. Thank you.